Welcome to this explainer. Today, we're zeroing in on a piece of legislation that is fundamentally shifting how organizations handle information, the Kenya Data Protection Act of 2019. Look, if your organization touches personal data in Kenya, understanding this act isn't just a nice-to-have best practice anymore. It's literally the law. We're going to break down the legal text, focus on the exact requirements you need for registration, and really clarify the ongoing obligations you've got to manage to stay compliant. It's all about empowering you with clear, structured knowledge so you know exactly what to do next.
Okay, let's dive right into this and follow the complete compliance lifecycle step by step. Our agenda is 1. Introduction to data compliance, 2. The registration thresholds, 3. Navigating the registration process, 4. The data protection officer, 5. Ongoing core data obligations, and finally, 6. Securing trust and compliance.
Section 1. Introduction to Data Compliance, your license to operate. Think about it like this. You wouldn't just hop in a car and start driving down the highway without a driver's license, right? Well, compliance under this act is essentially your legal license to operate. You simply cannot legally process personal data without adhering to our source material today, the Republic of Kenya Data Protection Act, number 24 of 2019. This is the exact document that establishes the Office of the Data Protection Commissioner. That's the independent body tasked with overseeing the implementation, enforcing the rules, and maintaining the master register of data handlers across the whole country.
But before we go any further, you really need to identify exactly where you stand. Section 2 of the Act clearly defines two critical roles, and you've got to know which one you are. First, a data controller. This is the entity that determines the purpose and the means of processing personal data. Basically, you're the one deciding exactly why and how the data gets used. On the flip side, a data processor processes personal data on behalf of the controller. You're acting on their direct instructions. So take a quick second and ask yourself, which camp does your organization fall into? Because whether you're a controller or a processor, this act absolutely applies to you.
Section 2. The registration thresholds assessment phase.
The Act is incredibly clear under Section 18. No person shall act as a data controller or data processor without being registered. But, do you actually need to register right now? It's time to evaluate your own legal standing. Because the Data Commissioner doesn't just ask everyone to register blindly, they prescribe some very specific thresholds that trigger mandatory registration.
So under Section 18, the Commissioner uses a sort of rule of three to determine these mandatory thresholds. First up, the nature of your industry. Second, the sheer volume of data you're actually processing. And third, and this is absolutely crucial, whether you are processing sensitive personal data. Just for context, the Act defines sensitive data as highly personal things: a person's race, health status, property details, marital status, and biometric data. Keep in mind, even if you run a super small business, simply keeping employee health records or using biometric data for logins can instantly trigger these mandatory thresholds. You hit one of these, and boom, you have to register.
Section 3. Navigating the registration process. Taking action. Okay, so let's say you've assessed your operations and realized, yep, we hit those mandatory thresholds. What actually goes into the application? Well, under Section 19, it's a highly pragmatic checklist. You need to provide a clear description of the personal data you process and the specific purpose for doing so. You've got to list the category of data subjects, meaning whose data are you actually holding. You also have to provide a general rundown of the risks, safeguards, and security mechanisms you've built in to protect that data. And finally, what indemnity measures do you have in place to protect the data subject from unlawful use? Really, it's essentially a comprehensive health check of your entire data practice.
Now, once you're approved, the Data Commissioner hands you a shiny certificate of registration. But remember, compliance is an ongoing state. It's definitely not a one-and-done event. This certificate is only valid for a specific period of time determined when you apply, and you absolutely must renew it when it expires. On top of that, if any of those details you just submitted in your application change, the law strictly requires you to notify the Commissioner so they can update the official register. And be warned, supplying false details or just failing to update them is explicitly stated in the Act as a legal offense, so keep things current.
Section 4. The Data Protection Officer, your compliance personnel.
Moving on to personnel. Section 24 outlines 3 specific triggers where you are legally mandated to appoint a data protection officer, or DPO. You need one if you're a public body, if your core activities require regular and systematic monitoring of data subjects, or if your core activities involve processing sensitive categories of personal data. Now you might be sitting there wondering, great, do we have to hire someone brand new for this? Well, actually no.
The Act notes that a DPO can totally be an existing staff member, as long as their other day-to-day duties don't create a conflict of interest. They just need to possess the relevant academic or professional qualifications, which includes actual technical skills in data protection.
Section 5. Ongoing core data obligations, daily operations. Let's look at how this builds into your daily routine. Every single data operation your business conducts has to be governed by the foundational principles laid out in Section 25. Personal data must be processed lawfully, fairly, and transparently. It has to be collected for explicit, specified purposes, meaning you can't just hoard data just in case you might need it a few years down the line. It must be adequate, relevant, and strictly limited to only what is necessary. And you've got to take every reasonable step to ensure it's accurate and kept up to date. Honestly, these principles, they're the absolute bedrock of the entire Act.
Now, let's say you're planning a massive new processing operation, maybe rolling out a brand new software platform or a big data collection initiative. If that project is likely to result in a high risk to the rights and freedoms of data subjects, Section 31 says you've got to do a Data Protection Impact Assessment, or a DPIA. You basically have to systematically describe the processing, assess the risks, and plan out your safeguards. If your assessment confirms, yes, this is higher risk, you are required to consult the data commissioner and submit your report a full 60 days before you actually process any data. That's a major operational timeline hurdle you've got to plan for.
Okay, I want you to anchor this number in your memory right now, 72. According to Section 43, if personal data is accessed by an unauthorized person and there is a real risk of harm to the data subject, data controllers have exactly 72 hours to notify the data commissioner of the breach. And if you somehow miss that tight window, you've got to come prepared with legally valid reasons for the delay.
Now contrast that with this number, 48. If you are a data processor and you become aware of a personal data breach, your turnaround is even tighter. The Act dictates that you must notify the data controller without delay, and we're reasonably practicable within just 48 hours. Clear communication and a rapid, almost instant response are not just good ideas in this scenario, they are legally mandated urgencies.
Section 6. Securing Trust and Compliance, the Resolution.
So, we've gone through some heavy legal requirements today. The thresholds, the strict breach notifications, the impact assessments. But honestly, it all comes back to one core philosophy, found in Section 41. It mandates data protection by design or by default. You are required to implement safeguards right at the time you decide how you're going to process data. It can't just be an afterthought tacked on at the end. By baking data minimization, encryption, and pseudonymization into your operations by default, compliance essentially becomes an architectural choice. You're building a system that inherently protects privacy, and that is exactly what ultimately builds real consumer trust.
We've covered the definitions, the registration thresholds, the application requirements, and your daily ongoing obligations under the Kenya Data Protection Act. The requirements are crystal clear, and the Office of the Data Protection Commissioner is out there actively overseeing them. So I'm going to leave you with this final, critical thought to evaluate for your own organization. Take a hard look at your current systems today. Is your data processing registered, compliant, and truly ready? Thank you so much for joining me for this explainer, and as always, keep learning.